Thank you so much, Amber.
We can see your screen.
So I am Erin Choquette, the CEO of the Connecticut Paid Leave Authority. And today we are going to talk about Connecticut paid leave coverage for non-certified employees at public schools. First, I'm going to give an overview of the Connecticut paid leave program, and then we're going to talk specifically about the effects of Public Act 25-174, which is the law that is bringing schools into this program. And then we'll transition into your responsibilities as a newly covered employer under Connecticut Paid Leave and Connecticut FMLA. We will have some time for questions. When you receive the slide deck, you will also see an appendix that includes additional information that we probably won't have time to get to today, but may be helpful to you. So first, let's just talk about Connecticut Paid Leave. We're focusing today on public school operators. Public school operator is a term that was used in Public Act 25-174, and it is defined to include local and regional boards of education, interdistrict magnet schools, state or local charter schools, as well as an endowed or incorporated academy approved by the State Board of Education to provide special education, as well as cooperative arrangements between multiple boards of education as allowed by state law. We do include RESCs, or Regional Education Service Centers, in the definition of public school operators. So what is Connecticut paid leave? Well, that term applies to the Act, the program, and the agency. The Connecticut Paid Leave Act was actually signed into law in 2019 to create a source of income replacement benefits for eligible workers who need to take time away from their job for qualifying health or family reasons. This is a program for Connecticut workers by Connecticut workers. By that, I mean that the program is entirely employee funded. The money for the program comes from payroll deductions. So covered employers deduct 0.5% from their workers' paychecks up to the Social Security contribution limit. Just like Social Security, we call these payroll deductions contributions. The employers remit the contributions to the Paid Leave Authority. You can do it as often as you like, but you have to do it at least quarterly. The money comes into the Paid Leave Trust Fund, which is administered by the Office of the State Treasurer, which invests that money on our behalf. However, it's not considered to be state money. It is only money that can be used for the purposes of running the paid leave program and paying paid leave benefits. So what happens is if a worker needs to take time away from work for a qualifying reason, they apply to their employer for job protected leave under FMLA, but they can apply to the Connecticut Paid Leave Authority to receive money while they're away from work so they can keep paying their bills. We have been providing benefits since 2022, and we have paid over $1.2 billion to over 165,000 Connecticut workers in that time. We receive claims from every city and town in the state. So although this is new for schools, this is not new for us. So you are getting us with all of the shakedown crews already happening. If you remember nothing else about today, remember October 1st is the date that all of this new law takes effect, but also please remember that FMLA is a different law than Connecticut Paid Leave. FMLA stands for Family and Medical Leave Act, and actually, it refers to two different laws. There's a federal FMLA and a Connecticut FMLA. Federal FMLA covers schools, always has. Connecticut FMLA has never covered schools, but starting on October 1st, Connecticut FMLA will cover employees of schools who are not required to have certification under Chapter 166. FMLA, in general, are laws which allow workers to take unpaid, job-protected time away from work, meaning they can take up to usually 12 weeks, and their job has to be held for them. Employers are not required to pay people while they're out on leave under FMLA. An employer may adopt a policy that says, hey, we need you to use your sick time, or we're going to allow you to use your vacation time, or we've negotiated so that you have a short-term disability insurance policy. But those are all choices, they're not mandates. FMLA itself does not require income protection, and that is a gap that Connecticut Paid Leave was created to fill. We provide that income replacement benefits, but we do not constitute a separate source of job-protected leave. And by we, I mean the Connecticut Paid Leave Program, which is run by the Connecticut Paid Leave Authority. We're a quasi-public state agency. We have a contract with AFLAC, which processes our claims under our direction and supervision. But really the program is run by the authority. Please also be aware that Connecticut Paid Leave and Connecticut Paid Sick Days are not the same. Even though people use these terms interchangeably, they really shouldn't, because they really apply to two separate laws. The Connecticut Paid Sick Days law has been on the books for over a decade. Connecticut was one of the first states to actually mandate that employers provide a minimum amount of paid sick time. But when it was originally enacted, it only applied to a very small section of employees. In 2024, the legislature expanded that existing paid sick days law to cover more workers. It includes schools as well as municipalities. In 2025, the legislature amended that law to say, if you have collective bargaining agreements, boards of education, and municipalities, and those bargaining agreements establish certain increments of time during which people can use their accrued paid sick time, then those bargaining agreements still control. This was in reaction to some concerns raised in 2024, where schools and towns said, we can't operate with the flexibility that you want, basically. But please remember, those paid sick days are essentially wages, right? They're funded by the employer, and it's sick time or vacation time or whatever. They can be used by the worker for generally any illness. It could be a routine cold or flu, and it's only 40 hours a year for a full-time worker. Connecticut Paid Leave, on the other hand, is employee funded, and generally speaking, it's used for people who have a serious health condition, which I'll talk about later. And it's for longer periods of time. This is really all I'm going to say about paid sick days, because paid sick days are actually kind of under the responsibility and jurisdiction of the Connecticut DOL. But we do have some links that we'll share with you about information DOL has, and we also have a page on our website where we just describe the differences. So let's talk about this new law, which is why we're all here today. Public Act 25-174 is actually a very broad law that does a whole lot of different things. But if you scroll all the way to the end, you get to a few sections that relate to Connecticut Paid Leave and Connecticut FMLA. First, it defines public school operator, which is that definition I've already run through. Second, it mandates that employees of public school operators and non-public elementary and secondary schools who are not required to have a professional certification pursuant to Chapter 166 are covered by Connecticut Paid Leave and Connecticut FMLA, right? That's the headline. Your non-certified employees are now covered under these laws. To make that possible, to simplify some of the administration, the law also gives the Paid Leave Authority the discretion for how to account for alternate pay calendars when we determine eligibility and benefits. I'll talk about that in a few minutes. And it slightly modifies the eligibility requirements under Connecticut FMLA. Again, I'll talk about that in a few minutes. What does this law mean for you as a school or a representative of a school? It means that your school is now a covered employer, or will be on October 1st. You are a covered employer with respect to those employees whose positions do not require professional certification. Those employees whose positions do require professional certification continue to be excluded. Now, there is a provision that has existed in our law from the beginning that says employees of municipalities are excluded from our program unless the unionized employees of the municipality collectively bargain to be included. If that happens, then the folks who are represented by that bargaining unit, as well as any non-union employees, come into the program. It used to be that employees of municipalities also said employees of boards of education. Now it's bifurcated. An employee of a public school operator who is in a position that does not require professional certification is covered. An employee of a public school operator who is in a position that does require professional certification, we're really talking about teachers and administrators, but there's a broader definition. They can come in only if they are represented by a union that collectively bargains to come in. So that bargaining still is an option for your certified staff. But your non-certified staff do not need to be bargained in. As I mentioned, 25-174 also amends Connecticut FMLA. Now, schools have always been covered under federal FMLA, but they've previously been excluded from Connecticut FMLA. But now, as of October 1st, schools will be covered under Connecticut FMLA with regard to those employees who do not require certification, but the folks whose positions do require certification are still out. If you have questions about whether a position requires certification, you're going to do what you've always done, which is talk to the State Department of Education. You or someone at your school already has a relationship with their talent office, already knows the designated SDE district email address. And if you have questions, you write to them and you give them the job description and they will tell you, yes, this is a position which requires certification. Business administrator is one that, according to SDE, is always a question because it's determined by the number of functions that the person performs. So you're not going to change that process. So you probably already know which positions require certification, but if you have a question, connect with the SDE district email. We do get lots of questions about folks who are working under a durational shortage area permit. As you know, this is a situation where educators who do not yet have a certification are allowed to temporarily fill positions that require certification. So if you have a DSAP educator, they are in a position that requires certification, so those workers are excluded and therefore not eligible for CT paid leave. On the other hand, there are plenty of positions in schools where a professional certification is not required, like a paraprofessional or cafeteria worker, maintainers, office staff, regardless. Your school may prefer, if you're selecting amongst job candidates, to be like, hey, for this paraprofessional, we would love a certified teacher. But if the SDE does not require that position to be certified, that's simply a preference and not a requirement. Okay, so that they don't come into the, well, I'm going to say that backwards. They don't come into the exclusion, which means your preference does not prevent them from being covered. We know some folks have dual enrolls. Perhaps you have a teacher and they also do something that does not require certification. We really look at their primary role, and that's what determines if they're covered or not. As I mentioned, the law gives the paid leave authority the ability to determine quarterly wages. We use the quarterly wages to determine both eligibility as well as the benefit payment. We know that some schools allow some employees the ability to select amongst multiple payment schedules. Say they can pick, 10 months or 12 months or 10 months with a balloon payment. But their colleague across the hall is perfectly free to pick something else. Well, if the employee is given the option to select, then we determine the quarterly wages by taking the annual wages and dividing that by 4. The reason we do this is to ensure equity. If you have two workers who have the same title with the same work schedule at the same salary, they're going to be making equal contribution payments, right? Because it's 0.5% of that salary. Their benefits should also be the same. And we don't want it to be artificially inflated or deflated simply because of this payment choice. The other change to 25-174 relates to eligibility under Connecticut FMLA. So as I mentioned, it brings in the non-certified employees, but it also specifically says for those non-certified employees of schools, they have to be employed for at least 3 months during the previous 12-month period by such school. This is a slight difference from what the rest of us have, which is you have to be employed for at least the 3 months immediately preceding the leave. This really is just a way to sort of address the impact of the summer break. Okay, so a lot of technical stuff that I've given you, and you might be saying, that's great, but I don't know anything about this program. Tell me more about the basics. So let's do that. On the paid leave side, there's really two halves. There's the contributions and the claims. Again, the worker is the one who's paying that money. We take the 0.5% out of their FICA wages, or the wages that you use to determine their FICA, up to the Social Security contribution limit. Once they hit that limit, they stop the contribution. But this is a payroll deduction, and payroll is handled by the employer or potentially by a third-party payroll provider that you retain. So as the employer, you need to register with us at ctpaidleave.org. There's a whole page on how to do it. There's a video. It's very easy. But we need to know that you're supposed to do this, and we ask you for at least 2 contacts so we can get in touch with you. Then you deduct that 0.5% and you remit it to the authority. There's 2 ways of remitting the contribution. Again, it's all explained on our website. If you use, I have the name of the software, Munis or School ERP Pro, because we were told that those make up a substantial amount of the software that a lot of schools use in Connecticut. We've talked to the software developer and made sure that they are aware of the statute. They have assured us that their system can easily accommodate these changes, where you have to designate which people are required to be certified or not, and process the deductions. If you have questions about how to make sure that your system is up and running before October 1st, they said that their support staff are ready to go, and they're talking about doing some information on the state user groups. If you use a different payroll system, one that other employers use, again, we've been doing this for a few years now, so most of the other systems are kind of ready for this as well. At the Paid Leave Authority, we receive and reconcile those contributions. If there's an overpayment or underpayment, then we'll handle that with refunds or a bill. We do impose penalties for noncompliance. If an employer fails to take the appropriate deduction from the employee's wages, then the employer is now on the hook for that money, plus a penalty if they fail to provide contributions in a timely fashion. So you really want to make sure that you are on top of this. The contributions need to be provided, the payroll deductions need to be taken from all of the wages that are included in the first paycheck that is issued on or after October 1st. So when you register with us, you will see that there's a drop-down list. We've added 3 titles: non-public elementary school, public school operator in connection with non-certified employees. If you had any certified employees who collectively bargain in, well, 1, you'd have to tell us, but 2, you could register that way. One of the things we ask for is the date you first had Connecticut workers. Just put October 1st. We know you had workers before that, but that's the date that you are now subject to this law. So don't put a previous date, because then we're going to think that you owed us money before and we're going to send you a notice, and you don't want that to happen. One of the things that you can do once you register as an employer is you can give authorized representatives approval to ask us at the authority for access to some basic reporting about their employees' claim status. We don't give you a lot of information, candidly. We're not allowed to under the law. This is, an employee-funded benefit, and a lot of this information we're not allowed to share, but we are allowed to share the name, the case number, and the approval or denial status, and if approved, the dates of the claim and the weekly benefit amount. This is something that employers who have been with the program have asked for, and it's available. It's not something you get automatically just by registering. There are additional steps where you have to submit a request for this access. You'll have to sign an attestation saying you are authorized and you know it's confidential. All of that information is found on our website on the Employers tab. Again, that 0.5% is due quarterly. We do allow a 1-month grace period. So first quarter of the year ends on March 31st. We have until the end of April to get the money to us. So that's the contribution side. The claim side, you'll be relieved to know, doesn't involve you very much at all. The worker applies to us for benefits either online or by calling Aflac. They provide us with documentation. We really communicate with them. However, the worker is required to notify you that they are filing a claim. Most of the time this occurs when the worker says, hey, here's this employment verification form that CT Paid Leave says you need to complete. So your job is to complete that form and either give it back to the employee or fax or email it to us directly. We are creating a specific employment verification form for schools where one of the questions is, hey, is this person in a position that requires certification? And are they in a position where they are allowed to choose their payment schedule? It's a good idea to make sure your employees know about your PTO policies so that they can follow them, including if you have a short-term disability insurance. And you are, of course, as with many things, required by law to not discriminate and not retaliate. So pretty straightforward. Fill out a form and be a good employer. Meanwhile, the worker will be working directly with us to get us those documents, which we review and approve if we can, or deny and let them know why. And then we pay the benefits. We pay on a weekly basis. And we make eligibility decisions very quickly. And once we get the documentation in, we are making decisions within about 3 days. So it does turn around fast. If we deny a claim, the employee does have the ability to submit an appeal to the Department of Labor. So that is sort of on the slide. Okay. Quick reminder, if you have employees at your public school whose positions do require certification, they are not covered. So they will not contribute, they cannot get benefits unless they bargain in. If they bargain in and you have some other non-represented employee who is also in a position that requires certification, they might come into. Just so you are aware, in case you're involved with collective bargaining, we do have some rules about this. In particular, you can't do this retroactively. It has to be on a forward basis, and you have to notify us so that we know that they're covered. Collective bargaining really only applies to Connecticut paid leave. You cannot collectively bargain into coverage under Connecticut FMLA and expect Connecticut Department of Labor to enforce it. But you could always bargain over a policy that looks like Connecticut FMLA. It just wouldn't have that same DOL approval and enforcement. So let's talk about FMLA. Again, you are probably already processing FMLA under federal FMLA. So it should be relatively familiar to you. You just now will have to make sure that you're looking at both the requirements under federal FMLA and Connecticut FMLA. So again, the worker has to notify you that they need the time away from work. If you have an application form, they have to complete it. They have to give you supporting documentation. I will say, you probably need the same MedCert that we need. Take a copy of ours, we'll take a copy of yours as long as it's complete. We don't care if it says CT paid leave on it or if it says DOL. You have to make sure your employees know what your rules are, post the posters, process the requests, and of course, not discriminate. The Connecticut DOL has promulgated regulations about Connecticut FMLA, and it's all on their website, so please check that out. And again, you probably already know about the federal DOL. They have tons of information on their website. So what should you be doing right now when you're thinking about it? Well, make sure that your leave policy includes Connecticut FMLA. Make sure that everybody knows what your paid time off policies are and how they relate, and post the posters. Your employees are still required to comply with your attendance and call-in policies, and they are required to give you documentation. And then just because I am a lawyer, I need to say this, there are always other laws, right? There might be the ADA or other Pregnancy Non-Discrimination Act. So don't forget about the other things that you've already been doing. Okay. I keep talking about qualified reasons, so let's just quickly review those. They're mostly the same as federal FMLA, but there are some tweaks. Medical leave is leave for the treatment of one's own serious health condition. The definition of one's own serious health condition includes serving as an organ or bone marrow donor. It also includes pregnancy as well as recovery from childbirth. We treat organ and bone marrow donor and pregnancy as separate leave reasons for data purposes, but technically it's all under that umbrella. That's where you're going to see the most of your claims. At the Paid Leave Authority, about half of our claims are for someone's own serious health condition. And then you add in another, I think it's almost 20% that relate to childbirth and pregnancy. So that's really the bulk of it. But you could also get people who need bonding leave. That is leave that a parent would take. It can be used by both parents. They could do it simultaneously or sequentially. They take that time to develop that psychological and familial relationship, either with their newborn child or a child who's been placed with them for foster care or adoption. Bonding leave is also the leave type that you would use if they need to take time off pre-adoption or pre-placement to go to court or to travel to get the child. The thing about bonding leave is it can only be used by the parent, but the definition of parent includes the person who's going to raise this child. It doesn't have to be a legal relationship. Bonding leave can also be used at any time during the 12 months after the birth or placement. It doesn't have to be immediate. Then we have caregiver leave. Caregiver leave is leave that an employee takes if they need to provide physical or psychological care and comfort to a family member who has a serious health condition. This could mean taking them to the doctor, meeting with the doctor, just being with them. That counts, right? You don't have to be actively intervening in a medical way. There are 3 other types of leave that don't come up as often, but you should know about. Military caregiver leave is a special kind of leave that relates to a person who has a family member who is injured in the line of duty on active duty in the armed forces. Then there's qualifying exigency leave, which is leave that an employee can take if their parent, spouse, or child is either on active duty or has been notified of an impending call to active duty. And there are specific qualifying circumstances. There's actually 9. I won't go through them all, but like sending off ceremony or a welcome home ceremony or having to go make an appointment with a lawyer to update your will or with the bank to update your, power of attorney or whatever. Routine childcare does not count. So if your spouse who's on active duty is the one who normally takes care of your child and now they can't because they're been called up, the employee can't say, okay, well, I need to leave work at noon for the next 6 months. But what they can say is, hey, I'm trying to get my child into after school care, but they can't let her in until October 1st. So I'm going to need to leave early for the next 2 weeks. That would count. And then finally, there's the Family Violence Leave Act. The Family Violence Leave Act is separate from FMLA. Schools have been covered by the Family Violence Leave Act since its implementation, which was over a decade ago. This law says that employers with 3 or more employees must provide up to 12 days in a calendar year of job-protected time off to that worker if the worker has been a victim of family violence, and they need that time to obtain medical or psychological care or counseling, to obtain services from a victim services organization, to relocate if that's necessary due to the family violence or assault, or to participate in a court proceeding relating to the family violence or assault. Now, that law has been in effect for 10 years, but last year, in 2024, they expanded it to include victims of sexual assault as well as victims of family violence. So we call this safe leave as sort of our general reference. So you should be aware that you have to provide that time to your workers, and if your worker is taking that time unpaid, they can apply to us for benefits. Quick, just like call out about serious health condition. when you're talking about FMLA and Connecticut paid leave, you're talking about a serious health condition. Serious health condition has a 7-point definition in the law, which I will not go through, but the definition really says the person has to be incapacitated from work or school, which doesn't mean they're in a bed, right? They're not on bed rest, but they can't perform their regular daily activities or school or work activities, and they're receiving some sort of treatment from a healthcare provider. So there are a variety of examples. It could be that they have an overnight stay in a hospital. It could be that they have a chronic condition, which they're managing with care and treatment from a healthcare provider, and they see that healthcare provider at least twice a year. But sometimes there are flare-ups, right? Like they have a migraine and they need to take their medicine and they need to go sit in a quiet room with the lights off and not take care of 25 kids. That would count. It also includes long-term conditions where the treatment is not intended to cure. The treatment is really just for palliative care. And then, of course, it does include pregnancy. It's important to know that incapacitation during pregnancy includes, hey, I need to go to my prenatal appointment, as well as things like complications. So you really are looking at medical care with a healthcare provider to kind of ensure it rises to the level of serious health condition. The MedCert that the Department of Labor offers as a sample on its website has the information that you need to make this determination. The MedCert that we give employees to have their doctors fill out kind of enables us to get this information. You can't ask for their medical files. You can only get the MedCert. The other thing to be aware of is what we mean by family member when we're talking about caregiver leave. Federal FMLA has a very narrow definition of family. It is your parent or your spouse or a child who is under 18 or 18 and older who has a disability as defined by the Americans with Disabilities Act, which prevents that person from engaging in 3 or more activities of daily living. Small group. Connecticut says, no, we recognize that you have a broader definition of family that people are taken care of and need leave for. So it's your parent or your spouse. It's your son or daughter of any age. Disability status is not an issue anymore, as well as your sibling or your grandparent or your grandchild. It also includes an individual, the statute says, related to the employee by blood or affinity. What does that mean? Well, it's any person with whom the worker has a significant personal bond that is like one of those family relationships that I just listed, regardless of a biological or legal relationship. Essentially, it's your chosen family. This is fact specific. You can ask the employee to give you a writing that says, hey, I want to take leave to care for my great aunt. My great aunt is the equivalent of my grandmother. She played the role of my grandmother my entire life. That is a sufficient statement. You cannot require it to be notarized. It cannot be an affidavit. You cannot require supporting documentation, photographs, anything like that. Connecticut does not recognize common law marriages. So prior to this definition, people who were in a long-term committed relationship weren't recognized as being spouses because it wasn't a common law marriage. So you couldn't take leave for them. Now you could, and that's one of the areas where we see this being used. Again, we have a form, DOL has a form. It doesn't come up a lot. It's about 2% of our caregiver cases, and our caregiver cases are only about 12% of our overall cases. So it really doesn't come up a lot, but for the people who need it, it's essential. So just be aware of this. Okay, couple more sort of just basics, just so you have it. When people think about leave, most people think about, oh, someone's going to be out for weeks on end, right? They're thinking about maternity leave. They're thinking about recovering from surgery. And that happens. We get that a lot. We call it block leave or continuous leave. They're not working at all for a continuous period of time for a single qualifying reason. But that's not the only way people take leave. They could take reduced schedule leave, which is what it sounds like. You're working some of the time, but not as much as usual. So say you have a person in your front office who works 7 to 3 Mondays through Fridays, but has to leave every day at 1 for physical therapy. They're on reduced schedule leave. They will take a fraction of their leave each week and then get a fraction of their benefit. And then there's that intermittent leave. You see this a lot with chronic conditions where, they have that migraine and I need to go home. I'll be back tomorrow. Or maybe it's caregiver leave where, hey, I really need to take my dad to his dialysis appointment. So it's not all the time. It might be a relatively small amount of time, but it's covered and it's protected. FMLA provides up to 12 weeks of job-protected leave in a 12-month period for most leave reasons, and the Connecticut Paid Leave Program provides up to 12 weeks of benefits in a 12-month period for most leave reasons. These are your work weeks, so it depends on what the person actually works. If they work 40 hours a week, they have a 40-hour work week. If they have a 12-hour work week, they get 12 12-hour work weeks. There are two exceptions. There is a right to an additional 2 weeks during pregnancy. So this is sort of like the bonus that you can only access while you're pregnant. But if you need those prenatal appointments or you have complications or God forbid you get sick, you break your leg during pregnancy, you can use an additional 2 weeks that are available then, but then that goes away when the baby's born. And then also, as we've mentioned, the family violence leave law is capped at the 12 unpaid days in a calendar year. So, a person says, I need 3 weeks because I need to relocate. We would say we can only give you 12. All right, before we get to questions, I just want to give you a couple of things to just keep in mind. You do need to give notice to your employees about their rights under Connecticut Paid Leave and Connecticut FMLA. There is a template notice that's available on the Connecticut DOL website under their FMLA page, which you can take and modify appropriately. That is something that you will need to give to your workers. So because the law applies to you on October 1st, you really want to get that out and then thereafter give it to your new hires and then put it in your annual rotation. Again, for I don't even know how many times, applying for Connecticut paid leave is not the same as applying for FMLA. So your workers apply to you, the employer, for FMLA. They're probably not applying to you unless you're the HR director, but they're applying to HR. And then they apply to the paid leave program for the money. For us, the application is not complete until all required documents are submitted. We do let employees know that if they have trouble obtaining required documents, they can request an extension of time. And if they're dealing with obstinate employer or doctor, sometimes we do get involved. We do have subpoena powers. So, which brings me to number 4. Please complete that employment verification form. You're required to do it. You've got 10 days to do it. If you don't do it, you run the risk of being seen as interfering with your employees' rights, which is not something you want to do. And then finally, it's really important to know, particularly for schools, benefits are paid only for dates that the worker would otherwise have been scheduled to work, but for the leave reason. In other words, if your school nurse was not normally scheduled to work in July, they can't get benefits from us in July. And they wouldn't be drawing down on their FMLA in July either. This is not something that we adopted just for schools. This is true for all employers. In the old days, Pratt & Whitney used to shut down every August. If the factory shuts down in August, the factory shut down in August. It doesn't matter that you got sick or you had a baby, you weren't working because the factory is shut down. So that's true. We can't give you benefits if the reason that you're not at work is because you're not scheduled, because everybody is off, as opposed to I'm not at work because I had a baby, I'm taking care of my family member. All right, we'll take some questions now, so I'm going to stop sharing my screen, but before I do that, I'm going to just give you a moment to look at this page. If you think of questions later that you're like, I really would love to know what the answer is, check out our website at ctpaidleave.org. We have a lot of information on that website. We also have videos, we have fact sheets, we got tons of stuff. So your answer is probably there. Or you can submit a contact us inquiry and say, hey, I didn't find this anywhere. Could you please just tell me? And let us know if you want an email back or a phone call back, and you'll get an answer. Your employees, once they file claims, should direct their claims to the claim process. So when they file a claim, they'll get access to our claim portal. That's where they can get a lot of information, or they can call and talk to the claim processors at Aflac directly. Just so you know, this is a dedicated team at Aflac. They only work on our program. This is not their main number. So this is the number on the screen is really just for the employees who are filing claims. If you have questions about Connecticut FMLA, the Connecticut DOL does have information about Connecticut Family Medical Leave Act on their website. I included the very long title if you really wanted to type it all out, but it's also a link. They also have a dedicated email address and phone. You can call their call center if you have questions. And federal FMLA, the best source of information is their website.